So let's talk about something that's at the very core of our justice system. Imagine a court makes a decision, but you're just absolutely convinced it's wrong. Is that it? Is that the end of the road? Well, not always. Today, we're diving into the crucial right to appeal under the brand new Bharatiya Nagarik Surakshya Sanhita, or BNSS, and how it really provides a second chance for justice. This question right here gets to the heart of what fairness is all about. You know, when a judge in a trial court, say a magistrate or sessions court, makes a ruling, is that the final word? Is it just set in stone? Or can you go and ask a higher authority, like a high court or even the Supreme Court, to take another look? The answer to that is what this whole explainer is about. So here's our game plan. We've broken this down into 6 key parts. First, we'll get a handle on what an appeal actually is, our ladder of justice. Then we'll look at the situations where you actually can't appeal. After that, we'll cover the rights of both the accused and the state to appeal before climbing to the final stop, the Supreme Court. And we'll wrap it all up with a super quick summary. All right, let's get into Section 1. What in the world is an appeal? The best way to think about it is to picture our judicial system as a ladder. When a decision is made down on a lower rung, an appeal is basically the process of climbing up to a higher rung to ask for a second look. So what does that mean in practice? Well, an appeal is essentially a formal complaint. It's when one party says to a higher court, hey, I really think the court below me made a mistake, either on a fact or on a point of law, and I need you to fix it. This isn't just some random procedure. It's a powerful tool designed to correct errors, a right that's specifically created by law to make sure things are fair. Now, this is absolutely crucial. The right to appeal isn't something you're just born with. Section 413 of the BNSS makes it crystal clear. You can only appeal if a law specifically says you can. It's not an inherent right, it's a statutory one. In other words, the law itself has to provide the ladder. You can't just assume it's there. Which brings us right into Section 2. See, if the law gives you the right to appeal, it could also put up some roadblocks. So, when is that path up the ladder completely blocked? Well, there are 2 main situations we need to talk about. Okay, the first major roadblock is right here in Section 416. If an accused person gets up in court and straight up says, I'm guilty, and the judge convicts them based on that admission, well, they can't then turn around and try to appeal the conviction. I mean, it makes sense, doesn't it? You can't really complain about a decision you totally agreed to. But, and this is important, they can still appeal the sentence, maybe arguing the punishment was way too harsh or legally out of bounds. The second big roadblock, which you'll find in Section 417, is really all about efficiency. The law basically says for really minor or petty cases, we're not going to allow appeals. This is to stop the higher courts from getting completely buried in small cases so they can focus on the serious stuff. Let's break this down. This chart lays out the exact limits. For example, look at the Sessions Court. If the sentence is 3 months or less, or the fine is just 200 rupees or less, no appeal. And for a first-class magistrate, the bar is even lower for fines, just 100 rupees. These rules are basically filters, making sure the appellate courts can use their time and energy on the cases that really need it. Okay, so that's all about when you can't climb the ladder. So now for Section 3, let's talk about when you can. Let's focus on the most common situation. A person has been convicted, they think the court got it wrong, and they want to fight that decision. Section 415 lays out a really clear step-by-step path. It's a hierarchy. If you're convicted by a magistrate, your first stop. The next rung up the ladder is the Court of Session. If you're convicted in a sessions court and your sentence is for more than 7 years, your appeal goes up to the High Court. And in those really rare cases where the High Court was the first court to hear the case, the appeal goes straight to the top, the Supreme Court. It's a very structured climb. But wait a minute, the accused isn't the only one who can file an appeal. In Section 4, we're going to look at the other side of the courtroom. What happens when the government, the prosecution, thinks a sentence is just too light for the crime? And this slide right here shows the huge difference in why they appeal. The accused is usually appealing the conviction itself. They're saying, I'm innocent, or the trial was unfair. The state, though, they accept the conviction. They're just saying the sentence was way too lenient and doesn't fit the crime. And Section 418 is the legal tool that gives the state the power to do exactly that. The government can tell its public prosecutor to file an appeal just because the sentence wasn't enough. The path is pretty similar to the accused's. A magistrate's sentence gets appealed to the Sessions Court, and other sentences go up to the High Court. But here's the really fair part. The court can't just increase the sentence without giving the accused a chance to stand up and argue against it. The Bharat Kumar case is a perfect real-life example of this. So here's what happened. A man was convicted of murder, but the trial court only gave him a 10-year sentence. The state appealed, saying that was totally inadequate. The High Court agreed and bumped the sentence up to life imprisonment. The Supreme Court later backed this up, pointing out that for the crime of murder, a 10-year sentence wasn't even a legally valid option to begin with. It just goes to show how a state appeal can fix some really big mistakes. So we've climbed our way up from the lower courts all the way to the High Court. Now for Section 5, we've reached the very top of the ladder, the Supreme Court of India. Getting a direct line to the Supreme Court is not easy. It's saved for the most serious, most dramatic situations. I mean, just imagine this for a second. A trial court says you're not guilty, you're acquitted, you're free. But then the state appeals, and the High Court flips that decision completely, convicts you, and gives you a massive sentence. That is a life-changing, whiplash-inducing turn of events. And the key takeaway from Section 420 is that all three of these conditions have to be met. It's not one or the other. The High Court has to 1, reverse an acquittal, 2, convict the person, and 3, hand down a really severe sentence. We're talking 10 years or more, life imprisonment, or even the death penalty. It's only when that perfect storm of events happens that the law automatically opens the door to the highest court in the country. So why does all this matter so much? This quote just captures it perfectly. A successful appeal isn't just about winning a legal argument. For the person involved, it means the conviction is gone, wiped clean, as if it never even happened. The punishment is gone, and that social stain, that personal stigma of the crime, is totally erased. It's about giving someone their life and their reputation back. Phew, we have climbed the entire ladder of justice from bottom to top. Now for our final section, let's just do a quick run-through of the key points you absolutely need to remember. All right, let's do a rapid-fire summary. Number 1, an appeal is a right given by law, not an automatic thing. 2, you can't appeal if you plead guilty. That's Section 416, or in really minor cases under Section 417. 3, the accused person's appeal climbs the court ladder, as laid out in Section 415. 4, the state can appeal a sentence that's too light under Section 418. And finally, number 5, Section 420 gives that special pass to the Supreme Court when an acquittal gets flipped into a major conviction. And that brings us to our final thought for the day. Look, this whole process of appeal, it definitely adds time, it adds cost to legal cases, but it's also a fundamental safety net, a check on the power of the courts. It's a system built to catch mistakes and make sure that the final outcome is as fair and just as humanly possible. So I'll leave you with this question. In a system run by people who can and do make mistakes, just how essential is this ladder of justice for our faith in the law itself? Thanks for watching.